I don't give up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit.
If he thinks we can't do something, you're going to look at this judge and think I can't do something, young man?
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No. My turn.
A defendant walked into court believing he was untouchable. He claimed nobody could stop him, ignored court orders, removed his monitoring device, and continued contacting someone he was forbidden to contact. But when the judge discovered what was happening behind the scenes, his patience disappeared. After nearly 25 years on the bench, the judge delivered a warning that completely changed the courtroom.
Case of the people versus Marquesi Hankey.
Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, from 711.
All right, it's your motion.
Caretaker 4. So at the very least, the restriction on his phone privileges to contact me.
All right, well, before I hear from the people, counsel, let me just say, you came in here the first time, and, well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on a motion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number.
One major question from the judge. Where is the tether? The court expected the defendant to still have his monitoring device, but officials discovered that it was gone. The defendant had removed it. The judge explained that this was not a small mistake. He had already been given a chance to follow the rules, but instead, he continued violating the court's orders. The prosecutor then revealed even more disturbing information. After his phone privileges were taken away, the defendant allegedly found other ways to continue contacting the victim. Court records showed dozens of calls using different numbers and different account information. During those calls, the defendant reportedly said that nobody could stop him and that he would continue calling until his court date. To the prosecutor, this showed that he was intentionally ignoring the court. He removed his tether. He broke restrictions. And he continued behavior that the court had specifically prohibited.
We have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't give up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim with other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. he just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their pen number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So Judge, I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but yeah, it's close, but I did pretty good. I said it okay, right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. It's breaking by my child. I can't say that I'm not in here for nothing. You know, I obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. So, again, please show mercy. Please. That's all that matters.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. This bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, the PCC.
Yes, sir. Is all discovery complete?
And I would ask if possible, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 9 a.m. in person before Judge Perry.
That's right. Court does call the case of the people versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm hearing with and on behalf of James Dennis Whitley.
This is people's emergency motion to modify bond in this case.
I find it surprising that they're alleging that she's in danger, the prosecutor, and they don't call her to show up. She reached out to a friend of my client
Call her to show up to do what?
today to say, I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
All right. Have you seen it? 14A District Court of County, Washington, session, the Honorable Judge Simpson.
You may be seated. Court recalls the case of the people versus Whitley.
Assistant Prosecuting Attorney.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in Newton on behalf of Mr. Whitley, who's standing to my right. Mr. Whitley, can you state your name before, please? James Dennis Whitley.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years.
Judge looked directly at the defendant and made one thing clear. The court had authority. The defendant's belief that nothing could be done was about to be proven completely wrong. The judge explained that people cannot ignore court orders and expect unlimited chances. He told the defendant that he was not above the rules. The defendant attempted to apologize and claimed he was not trying to cause problems. But the judge was not convinced. He explained that mercy is available for people who show they can follow instructions and take responsibility. But according to the judge, this defendant had repeatedly shown the opposite. Because of that, the request to reduce or change his bond was denied. His bond remained revoked.
And never have I ever been insulted in the fashion you just insulted this court. No, my turn.
Sure.
The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. Happy. All right.
Another argument broke out when defense attorney James Bennett questioned the court's handling of an emergency hearing. The attorney suggested that the defense was not receiving the same treatment as prosecutors. The judge immediately rejected that accusation. After almost 25 years on the bench, the judge said he had never been insulted in that manner before. He explained that the court had always provided opportunities for both sides to present their arguments. The judge emphasized that his decisions were not based on anger or personal feelings. Instead of punishing the defendant because of the argument, he gave the defense more time to review evidence and prepare. But the message was still clear. The court will be fair, but it will not tolerate disrespect, ignored orders, or someone acting like they are above the law. Because eventually, every defendant learns the same lesson. The rules of the court apply to everyone.